Howdy, everybody. My name is Brian Foley. I am with Houston Criminal Defense Attorneys. We're going to be talking about Texas Penal Code 8.07. Just to start off, this is about age affecting criminal responsibility. So, can you be prosecuted for something if you're a kid? If you're an adult, can you be prosecuted as an adult? That kind of stuff. So, I'm going to give you the general truth that all the defense attorneys know, and then we're actually going to go into the statute, and I'm going to show you how complicated it actually gets when you read the law. But here's the basics of it, okay? There's always an exception to one of these rules. So if you just read these rules and then pretend that that's what the law says, you're going to be wrong every now and then. Maybe 1% of cases you're going to be wrong, but most of the time this will get you through, okay? If you're younger than 10 years old, there is no criminal prosecution. There are very different exceptions. We're going to go over those, but most of the time, 99% of the time, younger than 10, no criminal responsibility at all for what you do. From 10 to 17, under normal circumstances, you are going to be prosecuted under the family code, not necessarily the penal code. Now, they don't have separate offenses only for kids, but maybe except for a curfew. But under the family code, they use a civil process. It's not a criminal case. It's actually a civil case against a juvenile. And they can do rehabilitation, probation, things like that. They can even do a determinate or indeterminate sentence, which is kind of like going to jail, or you've heard juvenile hall, something like that. When I was a kid, that's what we called it, was juvie hall. But in any case, 10 to 17, that is your regular case. Now, you can get certified as an adult. We're going to talk a little bit about that as well if you're a juvenile between 10 and 17. And then 17 and up is regular adult criminal prosecution. So if your question is, why was my 17-year-old who's still in high school, why were they arrested as an adult and put in the adult jail? Well, because under the law in Texas, they are an adult. The regular jail is for everybody who's 17 and up. Okay, so now let's look at the statute. It is section 8.07 of the Texas Penal Code, titled Age Affecting Criminal Responsibility. A person may not be prosecuted for or convicted of any offense that the person committed when younger than 15 years of age, except, now you're thinking, Brian, how come you didn't say 15? Why did you only say 10 to 17? Like, what about this 15 age? Well, as you'll see, it's very, very small. This first part is very strange, all right? It says, if you're younger than 15 years of age, you can't be prosecuted except if you commit perjury or aggravated perjury when it appears by proof that the person had sufficient discretion to understand the nature and the obligation of the oath. So if you commit perjury and you're 13 years old, you could still get prosecuted in a juvenile case, all right? Number two, a violation of the penal statute cognizable under Chapter 729 Transportation Code, except for the conduct for which the person convicted may be sentenced to or imprisoned to imprisonment or confinement in jail. So it's talking about if you're under 15, you can't get prosecuted for like a traffic offense, okay? Then it says a misdemeanor punishable by fine only. That's a Class C offense. So like theft from Walmart, under 15, in general, a person may not be prosecuted for or convicted of any offense that the person committed when younger than 15 years of age, except these misdemeanors punishable by fine only. Okay, so you can get a traffic ticket, a regular traffic ticket, and you can get a regular Class C ticket. A violation of a penal ordinance of a political subdivision. So a city can make like a Class C traffic ticket, something like that. Number six, a violation of a penal statute that is or is a lesser included offense of a capital felony, an aggravated controlled substance felony, or a felony of the first degree for which the person is transferred to the court under section 5.02 of the Family Code for prosecution if the person committed the offense when they were 14 years of age or older. All right, so if you're 14 to 15, you can still be prosecuted for these first degrees and the capital felonies if you get certified as an adult. So 14 years old is the youngest you can be certified as an adult. Then number seven, a capital felony or an offense under section 19.02 for which the person is transferred to the court under section 5402J2A of the Family Code. And let's just jump over there to that section of the Family Code, and I'll show you that. waiver of jurisdiction and discretionary transfer to criminal court. The juvenile court may waive its exclusive original jurisdiction and transfer a child to the appropriate district court or criminal district court for criminal proceedings if the child is alleged to have violated the penal law of the grade of a felony and the child was 14 years of age or older at the time that he is alleged to have committed the offense. If the offense is a capital felony, an aggravated controlled substance felony, or a felony of the first degree, and no adjudication hearing has been conducted concerning that offense, or 15 years of age or older at the time the child is alleged to have committed the offense, if the offense is a felony of the second or third degree or a state jail felony, and no additional hearing has been conducted concerning the offense. And after a full investigation and a hearing, if the juvenile court determines that there is probable cause to believe the child before the court committed the offense alleged, and that because of the seriousness of the offense alleged, the background of the child, the welfare of the community, requires regular criminal proceedings. Okay, so that's getting certified as an adult. That's a whole nother lecture some other day. All right, so let's move on to subsection B. Unless the juvenile court waives jurisdiction under section 5402 Family Code and certifies the individual for criminal prosecution, or the juvenile court has previously waived jurisdiction under that section and certified the individual for criminal prosecution, a person may not be prosecuted for or convicted of any offense before reaching the age of 17 years of age, except as provided by sections 1 through 5. Do you remember what 1 through 5 was? That was like the class C's, the tickets. You can get a traffic ticket. If you're 15, you got a driver's license. If you're 16, but when you're 17, you're an adult. So that section we just read, subsection B, basically says if you're 17 and under, you're not an adult. You can't be prosecuted as an adult. You have to have certified as an adult because, if you're 14, because it's a capital murder or some really bad first degree felony, or if you're 15 or 16, then it could be, some other type of felony. Okay. So subsection C, no person may in any case be punished by death for an offense committed while the person was younger than 18. So that is part of Supreme Court case law. It was added to the code here, the Texas Penal Code, to reflect the Supreme Court decisions, which say no death penalty for 17-year-olds. If you're 18, good to go. Death penalty if you have a capital murder offense. So notwithstanding subsection A, this is subsection D now. Notwithstanding subsection A, that list of if you're 15, a person may not be prosecuted for or convicted of an offense described by subsection A 4 or 5 that the person committed when younger than 10 years of age. Okay, so what was A4 and 5? A4 was a misdemeanor punishable by fine only, and A5 was a violation of a penal ordinance of a political subdivision. Okay, so those are like Class C tickets. Then subsection E, a person who is at least 10 years of age but younger than 15 years of age is presumed incapable of committing an offense described by section A4 or 5, those regular Class Cs. This presumption, however, may be refuted if the prosecution proves to the court by a preponderance of the evidence that the actor had sufficient capacity to understand that the conduct engaged in was wrong and that the time has to be at the time the conduct was engaged in. The prosecution is not required to prove that the actor at the time of engaging in the conduct knew that the act was a criminal offense or knew that there were legal consequences to the offense. So you don't have to know there's a law against stealing if you know that stealing is wrong. You could be prosecuted between 10 and 15 years of age if the prosecutors really want to get you. So let's say you are like 30 years old and you realize you want to steal some stuff, but you don't want to steal it yourself because you could get in trouble, right? So you get a kid to do it. Well, if you get a kid to do it between the ages of 10 and 15, they are presumed incapable. If they're younger than 10, you can't prosecute them. Okay. But if they're between 10 and 15, then if the prosecutors think that this child understands this is wrong, they could actually prosecute the child for a Class C offense under subsection A4 or 5. Okay. Pretty confusing, right? Let's go back to what I said at the beginning. If you want the basics of this and you want to have this understanding, it's going to be, if you're younger than 10, don't prosecute. If it's 10 to 17, maybe a juvenile case. And if it is 17 and up, we are talking about regular adult criminal prosecution. You're in trouble if you get a DWI at 17. If you get caught shoplifting, you're going to the regular jail. Do not pass go, do not collect $200, right? This is Texas. It is 17 and up. 17 is also the age of consent for other activities, but we won't talk about that today. And that is Texas Penal Code 8.07. Thanks for watching.